Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we're a law firm that works solely on technology, cybersecurity, and legal issues. In each episode, we look at stories in the law relating to digital technology from around the world, with an emphasis on data protection and cybersecurity. I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague Peter Wright, and we're just going to run through some news stories that have been coming up this week. So I will pass over to Peter to introduce himself, and then we will get started.
Thank you, Amelia. My name is Peter. I'm a solicitor and the Managing Director at Digital Law. And even though it's only 7 days since our last recording, there are quite a few things to cover. So I will pass back to Amelia to kick us off.
Thanks, Peter. So we are starting with the ICO. This is the UK Information Commissioner, and they have warned that some of the UK's top websites are facing enforcement action if they do not make changes to comply with data protection law. So specifically here, the ICO are talking about cookies. And I don't mean the really nice baked goods. No, I mean those really irritating pop-ups you get when you visit a website, or should I say that you should get when you visit a website.
Yeah.
And so some websites here on these cookie notices are not giving users fair choices over whether or not to be tracked for personalised advertising. So the ICO has previously issued pretty clear-cut guidance for organisations, essentially allowing users to reject all advertising or accept all. And websites can still display adverts when users reject all tracking, but these must not be tailored to the person browsing. But clearly, the message has not hit home, and we might see some big hitting enforcement action here.
Yes, and arguably I think it's necessary because we spend a lot of time advising our clients on just this thing, trying to make sure they have clear cookie banners in place, making sure that they have full transparency in terms of what cookies are being put on, in terms of the sort of tracking they do and how long they stay on a user's device. And very often we do get pushback in terms of, well, I don't see anyone else is doing this to the same degree, and why am I doing it like this? And I've had to take a look on a much bigger site and they're not doing it, so why should I? And the answer is that we are always just trying to say, well, this is what the law of England and Wales requires. But it is an issue that the standard of compliance varies so much, in particular with some of these larger players. And of course, an awful lot of people will look and think, well, hang on, such and such a company isn't doing it. Why should I? And arguably that's a fair point of view. So I think it is therefore something that the ICO is saying this, and I think is probably going to have to carry out enforcement in order to make an example here. I think the other issue is, I think since the UK left the European Union, there's been a school of thought that says, oh, the first thing they'll get rid of will be they'll get rid of the cookie law and get rid of all these banners, and aren't they terrible? And of course, it actually shows the fact that this isn't low-hanging fruit or an easy thing to do. Otherwise, it would have been done. Let's face it, I mean, the government's looking for easy wins, and I think, therefore, if it could have done this, it would have done. But the simple fact is it has not. That's probably to do with the UK adequacy decision from the European Union and not wanting to diverge too far from EU GDPR with the UK regime. So therefore, to use a horrific phrase, we are where we are. And therefore, if you're going to keep that law, you're going to have to enforce it. And having sort of sat on the fence, the ICO is now realizing we do have to do this. If you want to see an example of how this should look, go to the ICO's website. You get a large cookie banner that says accept all and reject all. And it doesn't make it difficult to reject all. It doesn't impair the operation of the website if you hit reject all as a user. And that is the definition of what you're supposed to get under GDPR. But it is the case that increasingly you're getting these massive cookie banners that, if you're viewing a site on a mobile device, often mean you can't even get through to the website if you decide to hit reject all, because the banner is so unwieldy that you simply, A, can't hit reject all. It will then impair the function of the website, and ultimately you think, well, is it really worth bothering? So it really is getting to the point where, yes, we do need the enforcement and a clear push by the ICO to say this is what you should be having on your website, because Otherwise, you're just going to get this smorgasbord of different standards in terms of how organizations are complying with it. And the vast majority of people who don't sort of wait on bated breath for what the ICO says and does on their website will not be aware of exactly what they should or shouldn't be doing.
Another facet of this, Peter, is you've already mentioned how we advise our clients, but equally looking at when our clients have come to us with complaints. So we have
Yes.
seen an increasing amount of individuals who are making complaints about the use of cookies, and this often comes down to whether the cookie notice has been drafted correctly. And Peter, I'm sure you can explain this in more detail here.
Yeah, so there is a cottage industry out there of individuals sending out standard templated letters to any organization with a website, basically saying, I visited your website and I was appalled that you went and installed a cookie on my device, despite the fact I didn't want, need, or ask for it. And I'm so upset by this that I now demand compensation. And they usually try and claim about 500 quid per cookie. So we've had a number of clients with letters demanding, £1,500, £2,000, £2,500 just for someone having gone onto the website. Now, of course, it is ridiculous to state that you are able to make that sort of claim, and indeed, the authorities that they then try to refer to very often either don't exist or it is misleading the way that they have quoted them in the letter that they've sent to the business. But the point is, the organisation is receiving such a letter has then had to come to us. We've then advised them and then represented them, sent a few letters to make these individuals go away. Do they end up issuing claims? No, of course they don't. But the point is that for a lot of organisations, it's like, well, do I just pay these individuals to make them go away, or do I instruct someone to help me make them go away? And therefore, I think some organisations do tend to think, well, let's just pay them to make them go away. But of course, you pay them to make them go away, and they'll just come back again with a slightly different complaint and have a second or third bite of the cherry. So really, it is worth having good, clear compliance in place on your website, making sure that you do have the accept and reject all banner, and then also making sure, of course, that when you hit reject all, that it works. Because if you do end up installing non-essential cookies on a user's device, despite them having hit reject all, you'll again potentially have them sending cheeky letters like this.
Thanks, Peter. So moving on to our next story here, we are looking at kind of look from here is the Financial Times story. So this is looking at internet browsing and the data that's being collected and sold in greater detail than previously thought, essentially increasing the likelihood that individuals' identities can be ascertained from anonymized information. Quite a lot to unpack in that.
There is. This is basically on the back of a report from, I think it was the Irish Council for Civil Liberties. And they have done an analysis of data that is available online. In theory, this is data that's entirely legitimately available from different data brokers who provide this information through legitimate channels. So, we talk a lot on this podcast about data that's been hacked and it being available for fraudsters to use on the dark web. That's not what we're talking about here. This is entirely legitimate data, but the point is it's been scraped. In theory, it is being offered in an anonymized or pseudonymized manner, but this analysis basically worked out that by taking certain data points, for example, GPS tracker data and other vague identifiers, that in of themselves might not be classed as being personal data, but you add them together and it meant that you could actually start to get a fairly good idea of the sort, even if it wasn't identifying the individual, you got a fairly good idea of the sorts of things they did. And the rather worrying categories that they put together based on the data that they had analysed was that you could, for example, say, I want to send an email that will target judges, or that will target elected officials, or military service personnel, or military families. All from, as I say, freely available information that's been scraped, and then that information is then for sale. Regrettably, it's then, of course, not too many leaps to say that organizations in China could buy that data, and once it's in China, you're then subject to local security laws that mean that the government there can request that data, and there is nothing that the company can then do to stop that data being provided to the central government. So there are real questions here from a security perspective in terms of how that data could be used and or misused by foreign state actors. But there is also the concern that this data is being used in such a way that circumvents current data protection laws that encourage organisations to anonymise or pseudonymise data, because of the stated policy of the regulators, which has always been, if you end up having data that is anonymised or pseudonymised, data protection laws fall away. And this is showing that actually no, if that data is anonymised or pseudonymised, it might still be enough to then potentially come back and be able to be used to, if not identify an individual, certainly to identify a cohort of individuals in potentially important places within the functioning of a industrial democracy.
Not at all scary, and I'm glad we've left this story kind of in the middle of this podcast because we do tend to normally end on somewhat of a scary note.
Yes. But let's try and pull ourselves back up.
Yeah.
Okay.
Well, we are next looking at the British Library. And so the British Library has confirmed that a cyber attack in October has led to a leak of employee data. So the attack, which took place on the 31st of October, has also resulted in the library's website being down for almost a month. So the Reseda ransomware group claimed to be behind the attack, and they say they will auction off the stolen data. The cyber gang say the price for the data, that includes passport scans, has been set at 20 Bitcoin, which is considerably less than it was around this time last year, but nonetheless, still just over £500,000.
Indeed. So there appears to be some dispute here in terms of what data is actually at risk here. The hackers say it includes passport scans, and that's one of the reasons why they're setting such a large price for the release of the data. However, the British Library is saying there is no evidence the data of users has been compromised, and it hasn't said whether the data that is compromised could instead relate to employees. The National Cybersecurity Centre, UK NCSC, has also been involved working with the library to try and fully understand the impact of the incident. The concern here, though, is that the British Library retains a copy of every piece of printed material issued in the UK. That is a problem when it comes to things like, copies of every website published. It tries to do that, but probably struggles to stay up to date. But certainly everything published in hard copy, copies of magazines, newspapers, books, periodicals, things like government legislation, copies of Hansard, which relates to parliamentary debates. All that sort of information is the stuff that the British Library keeps for the benefit of the nation. If a major piece of infrastructure like that is being successfully targeted, not even by a foreign state actor, but just by a hacker collective like this, that suggests that the government's measures to protect critical national infrastructure are not necessarily as robust as they might wish that they were. So it's quite right that the NCSC is working on this, and I would hope that this would be a lesson to say that certainly if the British Library systems have been compromised, that then lessons are learned from that in terms of how to keep other large-scale IT systems that public bodies rely upon. Very often those systems are a little bit old, a little bit full of legacy technology that needs to be patched and kept secure, and can therefore be exploited by people who know what they're doing, leading to issues like this. So a lot to learn from this, and hopefully trying to be positive on it. Hopefully this will mean that other significant public institutions don't get compromised in a similar way.
And equally, I should hope after this, the British Library do indeed pull their socks up to prevent this happening again.
Yes, but that would also involve an investment probably in IT and tech. And the problem is an awful lot of the public sector at the moment doesn't have the resources to do that, given the state of the UK's public finances, which aren't great at the moment and haven't really been particularly great for the last 10 years.
On that note, we will move over to looking at the NHS.
We were getting positive there, and we've crested and crashed back down, unfortunately.
Wow.
Okay, NHS.
NHS.
This will be a good one. Okay.
So, a former NHS employee has been found guilty and fined for illegally accessing the medical records of over 150 people. So, this individual is Loretta Alborgetti from Redditch. She worked as a medical secretary within a department of Worcestershire Acute Hospital NHS Trust, where she illegally accessed records. So, in June 2019, which you might notice quite a while ago, the complaint was raised by a patient who was concerned that their medical records had been accessed by an employee. And the investigations subsequently revealed that the individual had accessed the records 33 times between March 2019 and June 2019, without consent or a business need to do so. This report further discovered that the individual had accessed a total of 156 patient records without consent or a business need, viewing them over 1,800 times within a 3-month period. This included records of family members and individuals with postcodes local to where she lived at the time. So, what did you say, Peter? A busybody? Was that the words?
And the fact that it turns out this was all family and friends and neighbours, and the fact that this was done 1,800 times. I mean, as you said, Amelia, it's like, well, you'd think if they were a critical care nurse that it would be, well, you only have other things to do during this period. But anyway, they seem to go online excessively just within this 3-month period, looking in repeatedly at the progress of different people's patient records, their conditions, treatment. There's medical records can be incredibly rich troves of information, particularly if you've got people who are requiring ongoing care and treatment. I think there's 2 things to take away from this. One is the sheer length of time it's taken for enforcement here. This person ends with them pleading guilty at Worcestershire Magistrates Court. They ended up being fined, I think it was about £600. However, this relates to offences between March and June of 2019. I know there was a pandemic. I know that the courts were closed. I know that there are backlogs. I know that this would have been seen as a non-urgent matter for the Magistrates Court compared to, say, more violent crime that needs to be dealt with in that Magistrates Court. But still, 4 years for that to get a decision is somewhat lengthy. Indeed, I was actually on a podcast last week explaining the fact that a mooted High Court action that everyone was getting very excited about in the world of Formula One, it would take years to get anywhere, if it even got anywhere near a final hearing. But unfortunately, it sort of served to pour cold water on their excitement of possible large-scale litigation when the courts are simply so full that anything that is potentially complex like that is simply going to get booted into the long grass. So you're sort of looking at 4 or 5 years to get anywhere. Even a fairly simple thing like this, it's taken 4 years, which I think tells you pretty much everything you need to know. Second thing to take away from this, though, is also the fact that if you are in a job where large volumes of personal data are being processed, just because you work there, it is usually explained to you in your training that if you are not required to look at someone's file for the purposes of fulfilling the responsibilities and obligations of your employment, you aren't allowed to go on a fishing trip and just look at information anyway. So the same principle applies if you work in a bank. You can't suddenly go, oh, let's have a look and see what so-and-so's account's like. Oh, that's a big payment they've paid to go on holiday, or you simply aren't allowed to do that. Yet I have heard that this does happen, where bank staff do end up looking at accounts that they do not need to look at. They're simply doing it out of sheer curiosity. And in the same way, that is a criminal offence and can lead to the same problems. And of course, bear in mind that if you are doing this, the system that you're using to log in will record the fact that you've logged in and viewed that information at a specific time at a specific place. So it's not as though if someone does then think, oh, I wonder how that person knew that I'd spent money on that, or that I was going to go and do such and such a thing. it won't take too long until people start asking questions, and unfortunately, the electronic footprints are usually there for everyone to see, unless you know what you're doing and know how to hide them.
And you mentioned training there, Peter, and that's kind of a really important point. The fact that actually staff should be receiving training in terms of any level of data protection, because it doesn't matter whether you are a junior person or you are very senior, everyone needs to understand the basics of data protection, because who knows, we don't know the ins and outs of why this individual was accessing this data, but had she received the correct training, she may well understand the consequences of her actions in more detail before she started.
Exactly. I think it's a received and understood thing. So it's, did you understand what you are being told in that sort of induction training that you should receive before working in something like the medical profession? So when you start working at the NHS, I would expect, arguably on the first day, certainly within the first week, you will be required to undertake some training on data protection before being unleashed on the system, particularly when you are exposing yourself to criminal liability if you end up using that information in a way that is not permitted for during the course of your employment. So yes, that's the sort of thing that should be delivered early on. So either they didn't understand that they were committing an offence, or they did and didn't care and didn't think that they would get caught and didn't think what the sanction would be. But guess what? You've now got a criminal record that has to be disclosed. And guess what? You're never going to get, that will have an impact on ongoing employment and has to then be disclosed if you're applying somewhere else. So that can have a pretty devastating effect, even though the practical implication is only a £600 fine.
Thanks, Peter. So moving on and kind of looking at fines and money here, we are looking at the class action settlement that has been proposed in the case against Safe Capital One and Safe Capital Bank, and all of the Capital One, essentially their kind of umbrella terms. And we are including in this Amazon Web Services as well as the defendants. So this is relating to a data breach that Capital One announced in July 2019. And if you're a settlement class member, there'll be benefits available from the proposed settlement. So we're not coming at this from looking at the settlement. We're looking at this in terms of the ICO and how they may well respond to this.
Yeah, so this is a US class action settlement against Capital One Bank USA for $190 million. And that will be split amongst a large cohort of members. It's a US bank with hundreds of thousands of users who could have been affected by this breach and will be entitled to claim under various headings for a slice of that $190 million. So this doesn't mean that people are going to get millions of dollars in a settlement, or indeed tens of thousands of dollars by the time it works itself out. It's interesting here that while this is a settlement, it was a settlement of ongoing litigation from this breach that occurred in July 2019. So this settlement is only occurring because Capital One have been engaged in that litigation, and this has been the only way to make that litigation go away, is to end up writing a check for that 190 million. And that won't be the limit of their liabilities, because then they'll have to pay probably the costs of the claimants that will have been incurred, their legal costs, as well as their own costs in administering payouts from a fund of $190 million. So you can probably double the total liability here. They're probably looking at the thick end of $500 million in terms of what they're going to have to pay out, which is a lot. But for a bank the size of Capital One Bank, probably still not exactly massive. And it's also worth remembering that this is from a breach in the US. The law in the US varies from state to state, but generally in the US, large organizations or any organization doesn't publicize the fact that it's been breached. There is no data protection regulator at the federal or state level in the US. So they don't have to report breaches. They don't have to go public on it. The only time they have to go public is if they are a publicly tradable company. And in this instance, of course, they will have had to then tell the stock exchange where they are traded that, yes, we did have this breach. Otherwise, they would have been in breach of rules set by the Securities and Exchange Commission, i.e., you would have known that there was an impact from that breach and you hadn't told the market, and it would have had an impact on the share price. So there we go. That's a whistle-stop tour through what happens in the US here. The contrast is in the UK. You would have to go and report a breach like this to the UK Information Commissioner anyway. But also you tend not to get large class actions like this in the UK. They've tried to do one in relation to the British Airways and Marriott data protection breaches, which led to the fines that were issued in 2019, but they've never really got off the ground. Pardon the pun. So it's very much the case that we've not really had these sorts of style settlements in the UK or largely in the EU. Instead, it's been the world of regulatory enforcement and large fines from the regulators. And also coming back to what I was saying about litigation being a long-winded process, that is the problem, certainly at a UK and EU level, is that it just does take so long at the moment to try and get anywhere when it comes to litigation, that those sorts of large-scale class actions simply have not manifested themselves or have been defended sufficiently vigorously that they simply haven't been able to become established. But instead, you've had these large-scale fines in the tens or hundreds of millions against some of the large tech firms like Amazon, WhatsApp, etc., for some of their large data protection breaches in Europe. In the UK, we've not had breaches of quite that size, but we're diverging from the point here. The point is that, yes, this is an example of the fact that, if anything, the big deterrent in the US at the moment is class actions like this, which is very different from the regime in Europe.
Thanks, Peter. So moving to our final story of the episode. So we are looking at the Digital Markets, Competition and Consumer Bill. So if you're a keen listener, you may have remembered us talking about this in brief last week when we discussed the King's Speech. So this bill is set to introduce a new targeted and proportionate regulatory regime to address concerns around competition in the digital industry, while ensuring that the UK remains one of the best places to invest and innovate new technology. So I had to add that. So essentially at the heart of the bill is a new approach to digital market regulation, allowing the Competition and Marketing Authority, the CMA, to intervene quickly and flexibly to promote competition. So Peter, why is this bill so important?
It's important because it sets out the future regulatory environment for an important part of the UK economy, and a part of the UK economy that has the greatest potential to innovate and grow as a percentage of the UK economy over the course of the next decade. The sort of press release that announced these changes was very quick to sort of bang the drum for the tech sector in Britain. Talks about the UK being the third country in the world to establish a tech sector valued at more than 1 trillion, and the fact that this was greater than the size of the French and German tech sectors combined. So therefore, the regulation of that market and creating the right environment is important. It is important to be able to have regulatory decisions that give confidence to the companies that have invested in it and are working in the UK market. And I think we have to look at what's been announced here with regards to the fact that they're wanting to allow tech firms that they can challenge regulatory decisions on the grounds of proportionality, and there's a clear process that can be followed, and that it is hopefully encouraging a model of the regulators working closely with the big tech players, and hopefully avoiding the problems that presented themselves earlier this year with the Microsoft Activision Blizzard regulatory decision, which led to one of the world's largest ever takeovers being blocked by the UK Competition and Markets Authority, who basically said that they were not happy with the terms of this potential deal, despite the fact that it was being greenlit by regulators in Europe and the United States. There was a rather unpleasant episode where the chief executive of Microsoft then, I think he appeared on one of these sort of breakfast radio, the Today program on Radio 4, and said some rather unpleasant things about the UK government and economy, and said that the UK was closed for business, and it was very disparaging about the UK's regulatory regime when it came to technology. When after a few changes and negotiations, then the UK Competition and Markets Authority greenlit that takeover of Activision Blizzard in October. Suddenly he said, oh, the UK is a great place to come and do business and innovate and invest. And I was totally wrong with what I said earlier in the year, and I shouldn't have appeared on the radio when there was a big time difference and I was very, very tired. So that's okay then. But the point here is that the UK is moving to try and shore up confidence in its regulation of digital markets, and is also reflecting some of the changes at an EU level now that you've had the Digital Markets Act and the Digital Services Act coming into law in the European Union, regulating the operation of the tech sector there. This is an attempt by the UK to say, look, we have a regime that can give confidence to the market, but also trying to say, but we're actually a little bit better for investment and a little bit more light touch, and we're a little bit more business focused and business friendly, and come and invest in the UK rather than taking your money and investing in Europe. So there's a lot sort of tied up in this for that reason. It's interesting that on the back of the King's speech, this is one of the first big pieces of legislation mentioned in that speech, which is now receiving the benefit of government support and government time to try and get this through Parliament in the government's remaining hours before the next general election.
I think it's also worth pointing out here that this new bill will also enable the CMA to encourage the most powerful firms in the digital market world to work with regulators to ensure that competition is maintained, but also then allowing legal challenges to cause the regime to get bogged down in the courts. So this here is, we've just seen in many of our stories today where the courts have had quite an impact on the story, and this has been dragged out. Realistically here, the idea is to not get things stuck in that kind of vicious cycle of courts, to move things forward far quicker.
Indeed, and it's trying to say, look, there are issues in the tech sector when you have some of the big players, particularly organizations of the size of Google, Apple, Amazon. There are issues at play there in terms of, in some respects, being construed as having significant market share or almost a monopoly in certain discrete sectors within tech. And therefore, active regulation and monitoring in those sectors is important to ensure that competition continues. But you still want to give confidence in organisations that they can come in and that regulation will be fair, open and transparent. However, also this comes with a big stick. So under this legislation, there is still a possibility that fines in the regions of tens of billions of pounds could be levied if the CMA is not convinced that some of these actions are anti-competitive. So you could therefore see significant enforcement if measures are taken that are felt to be sort of polluting the competitive environment within the tech sector. But then, of course, they will be able to challenge these decisions on their merits through the processes that are set out within this bill. So it's really important for the future functioning of, I'll say, a sector of the UK economy that the success or failure of that tech sector will have big implications for whether the UK economy can actually grow in any meaningful way over the course of the next 10 years. Let's hope that it can and that it does.
So that was our last discussion for this episode. But if you would like to hear more from us, including subscribing to our newsletter, as well as receiving information about subscriber-only podcasts, webinars and events, then please subscribe to Premium via our Patreon channel using the link in the show notes. A big thank you again to Anson Evaluate for helping to produce this podcast. And if you'd like to produce your own podcast or webinar, or you'd be interested to hear about Anson Evaluate services, please take a look at their website that you can find at www.ansonevaluate.com. Just a reminder, these episodes are available on our website, YouTube channel, podcast channels as well, such as Spotify, Apple Music, Amazon and Google Podcasts. And please feel free to leave us a review. And finally, if you have any questions about anything that we've talked about today, please email us at admin@digitallawuk.com, and we hope to see you again next week.